Hello and welcome to a special episode of Legal Wrangle on Indirect Taxes. Special because today we are covering 4 Supreme Court decisions related to taxability of Sodexo meal vouchers, input tax credit on exempted goods transactions, excise duty on branded tobacco products and interest leviable under Section 11AB of Central Excise Act on differential duty paid against supplementary invoices. Our first case is a very interesting Supreme Court decision where the issue involved is whether Sodexo meal vouchers are goods within the meaning of Section 225 of the Maharashtra Municipal Corporation Act and therefore liable for either octroi or local body tax. Well, the High Court thought so, but the Supreme Court did not.
The assessee company is engaged in the business of providing pre-printed meal vouchers which are given the nomenclature of Sodexo meal vouchers. Assessee enters into the contract with companies having a number of employees on their rolls. They provide meals and other items to their employees up to a certain amount. For utilization of these vouchers by such employees, the assessee had made arrangements with the various restaurants, departmental stores and shops. From these affiliates, the employee who were issued the vouchers could procure the food and other items on the presentation of the said vouchers.
The High Court held that these vouchers were goods and therefore subjected to tax. On appeal, the Apex Court held that the vouchers were not sold by the assessee to its customers. It was therefore not goods within the meaning of Section 225 of the Maharashtra Municipal Corporation Act and therefore not liable for either octroi or LBT. It also observed that the value of such free food and non-alcoholic beverage provided by an employer to an employee was treated as expenditure incurred by the employer and amenity in hands of the employee. In our second case, the Apex Court clarifies the position of input tax credit with regard to the exempted goods and exempted transactions. This decision also addresses the issue whether there is any extra cost burden in case input tax credit is paid in an exempted sale transaction instead of an exempted goods transaction. Let's have some more inputs regarding the case.
The assessee is engaged in the business of manufacturing asbestos cement pressure pipe and asbestos cement sheets. It had availed input tax credit on the purchase of raw materials used in the manufacture of AC sheets. The AO disallowed the input tax credit and charged interest. Further, the High Court held that the assessee, which was a manufacturer of AC sheets, was entitled to avail input tax credit and the authorities below were not justified in denying the benefits of same.
On appeal, the Apex Court held that there was a difference between exempted goods and other cases where a particular transaction, when it satisfies specific condition, is not taxable. Exemptions with reference to taxable events or taxable person would not exempt the goods as such. For a subsequent transaction or when the goods are sold or purchased by a non-specified person, the subsequent transaction or the taxable person would be liable to pay tax. The Supreme Court thus held that the input tax credit was rightly allowed by the High Court. In our third Supreme Court decision, the revenue is in appeal before the Apex Court challenging the order of the CESTAT whereby the tribunal has granted the benefit of exemption notification number 8 of 2001 and on that basis held that as assessee was not liable to pay any excise duty on its product known as Crane Gutka, which was containing chewing tobacco. Let's get some more facts from Shikha.
The assessee is engaged in the manufacture of pan masala containing tobacco, which is sold under the brand name Crane Gutka. Assessee claimed exemption and contended that since the assessee was not using the brand name of any third party but being a SSI unit, it was using its own brand name and therefore for the purpose of the said notification, it should be treated as unbranded product. This was not accepted by the Commissioner who had raised the demand for payment of duty at the normal rates of the said product.
On appeal, the apex court held in favor of the revenue by holding that once the goods were sold under any brand name, whether that belonged to the assessee or the third party, the goods would be treated as branded. The apex court further held that the definition of brand name as stipulated did not limit the brand name to third party brand name. Thus, the Supreme Court held that the judgment of the tribunal was unsustainable in law and was liable to be set aside. In our next case, the issue involved was whether interest was leviable under Section 11AB on the differential duty amount paid under supplementary invoices due to price increase by virtue of price variation clause in the sale contract. The assessee involved here is Steel Authority of India. Let's go to Shikha for some more facts.
The assessee is engaged in the manufacture of iron and steel products. The final products manufactured by the assessee were either directly sold at the factory gate or were transferred to the various branch sales office from where they were sold to the customers. As per the price variation clause in terms of the agreement with the Indian Railways, the price circular dated 24th February 2005, effective from the 1st July 2004, was revised upward with increase in the agreed upon price. The assessee also discharged differential with regard to the same, but the revenue demanded interest under Section 11AB on the duty paid.
On appeal, the apex court held that both the parties were not aware of the final price at the time when the goods were removed. When the differential payment was made at a later date, further amount towards excise duty became payable as a result of the said differential in price. It further observed that as on the date when the goods were cleared, there was no certainty that there would be price escalation, and it was beyond comprehension to ascertain the precision of such an escalation. The Supreme Court thus concluded that the matter was fit to be referred to the larger bench. In our second last case, the assessee, Quality Fabricators and Erectors, had filed a writ petition challenging the letters issued by the Directorate General, Central Excise Intelligence, which directed the respondent banks not to allow the assessee to operate the bank accounts. Let's have some more details from Shikha.
The assessee, a sole proprietor carrying on the business of fabrication and erection of plants, structures, etc., is registered with the Service Tax Department since 2008. The assessee undertakes the projects on turnkey basis as well as on work contract basis. Pursuant to investigation by the DGCEI, a show cause notice demanding service tax was issued. Assessee filed a reply denying all the allegations and asserting that the service tax due and payable in law had already been paid.
In the meanwhile, instead of any adjudication in relation to the demand and pursuant to the show cause notice, the banks have been intimated to freeze the accounts purportedly under Section 87 of the Finance Act 1994. Against these letters, the petitioner is before the High Court. The High Court favoured the assessee and observed that the Supreme Court in case of Harshad Shantilal Mehta had held that the word due did not refer merely to a liability created by the charging sections to pay the tax, but also refers to an ascertained liability for payment of tax quantified in accordance with the law. Based on the Apex Court decision, the High Court held that unless and until there was crystallization of a demand by proper adjudication order and on hearing petitioner, there was no question of any recovery. The court quashed the letters addressed to the banks for freezing the current accounts. In our last case, the key issue before the High Court was whether the action taken by the departmental officers regarding the attachment of bank accounts of the assessee was in gross violation of the rules and CBEC circular dated 1st July 2008. The assessee here is engaged in fabrication, erection and installation of power substations. Let's go to Shikha for some more details.
The assessee had availed Senbit credit of service tax paid by a subcontractor. An inquiry was instituted by the respondent under Section 14 of the Central Excise Act. In response to an inquiry, the respondents insisted that the Senbit credit availed by the assessee should be reversed. In spite of these oral directions, the Senbet credit was not reversed and accordingly a show cause notice was issued to show cause as to why recovery should not be made towards Senbet credit wrongly availed.
On appeal, the High Court decided in favor of the assessee by observing that the provision for attaching a property provisionally is of an extraordinary nature and should be resorted to in the utmost circumspection and with maximum care and caution. The authorities should have a reasonable belief that the assessee may dispose of or remove the property which would not be in the interest of the revenue. Therefore, a firm opinion should be formed that the interest of the revenue was required to be protected. The High Court thus quashed the order of attachment. Well, this brings us to the end of this episode of Legal Wrangle on indirect taxes. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to TIOL Tube to remain updated. It's free and we'll keep you updated on our new posts. Have a good day.